County, and we welcome you to our presentation. As you might have just heard, this presentation is being recorded, and the recording can only be used with the permission of the League of Women Voters of Manatee County. Please put any questions that you have in the chat, and our treasurer, Randy Miller, will be monitoring the chat and organize us for questions and answers at the end of my presentation. Just to briefly introduce myself, as I said, I am the Vice President of the Manatee League. I'm also the Secretary of the League of Women Voters of Florida. I am a retired Department of Defense senior executive. I spent 38 years in the Department of Defense and the U.S. intelligence community before retiring full-time here to Manatee County, where I pretty quickly got involved with the League to scratch my itch for being involved in a positive way in our community and in elections and voting. Today, we're going to talk about mid-cycle redistricting, both in a national level, but then we'll, as quickly as possible, get into what's happening here in Florida, which I know is of interest to many people. What we're going to cover today are a few facts about congressional districts and redistricting. We're going to have a very short social studies class on the rules and governance that surround congressional redistricting and how it has to be done. A little touch on what gerrymandering looks like in terms of approaches, some history of governance of redistricting in Florida, as we get zoomed in from national to our local situation. Then I'm going to talk very specifically about the 2025 to 26 redistricting special session, which occurred at the end of April, the legal challenges that are underway against the maps that were approved in that special session. And then I'm going to specifically go over how the new maps affected us in Sarasota and Manatee and in the congressional districts where Sarasota and Manatee are located. Okay, here's your brief social studies class refresher. In the United States, there are exactly 435 congressional districts corresponding to the 435 voting members in the House of Representatives. That number has been capped since 1929. And so what happens is they are reapportioned and redrawn as districts after every 10-year census. Across all of the 50 states, wherever and whenever there's been a population change that needs to be addressed, such that the districts would be redrawn. There are also 6 non-voting delegates and representatives in the House of Representatives for DC and the U.S. territories. So redistricting. Redistricting is a process that keeps our congressional districts equal in population size in keeping with the decennial censuses. When politicians manipulate the redistricting process to expand or protect their own power, that manipulation is called gerrymandering. Since the 1960s, mid-cycle or mid-decade congressional redistricting, the redrawing of lines between censuses, has been historically rare. There's 2 ways that it generally happens. One is frequent, one is rare. Court-ordered changes to districts. This is the vast majority of the changes. They are triggered almost inevitably by a court order that threw out the previous map for violating either state or federal laws. There have been nearly 40 instances nationwide of that since the beginning of the 2000s, frequently triggered to update maps in states like Texas, here in Florida and Pennsylvania. A lot of them happened in the 2010s. When you talk about voluntary redistricting that is not triggered or necessitated because of a court order or a Supreme Court ruling, those are very rare. From 1970 to 2024, only 2 states voluntarily redrew their maps mid-cycle for partisan advantage. We had an example in 2003 in Texas and another in Georgia in 2005. This all changed. Actually, I shouldn't have moved on. This all changed in 2025. Since the beginning of the current term, it's been clear that the president and the White House have wanted to protect the narrow Republican U.S. House majority in the 2026 midterm elections. They've said that quite clearly in order to prevent Democratic gains in the House, which would hamper the administration's ability to carry out their program and their plans from the executive branch. The National Republican Redistricting Trust was formed, and a presidential advisor presented the idea to push partisan redistricting to the president in April of last year, and he has been publicly calling for partisan redistricting ever since. Since that time, new districts, in some cases, tried to redraw their lines and were unsuccessful, at least to date. This was attempted in Arkansas, Indiana, Kansas, Maryland, New York, Virginia, and Wisconsin. You can see those color-coded on the map. There are new districts in effect since the call from the president in California, Florida, Missouri, North Carolina, Ohio, Tennessee, Texas, and Utah. Those that are in a planning stage but are not yet in effect include Alabama, Louisiana, and South Carolina. So I just want everyone to appreciate that historical perspective, that voluntary changing of districts that's not prompted by a Supreme Court decision or a judicial ruling are very, very rare. Voluntary redistricting without that kind of a trigger is very rare until the past year. Okay, so if you decide that you think that you need to conduct redistricting, what I'm going to cover right now is what are the rules or the governance under which that needs to be done. And the way that it's done is it's a combination of the U.S. Constitution, federal statutes that apply, judicial precedent, and then state-specific laws. And it's this combination, this hybrid system that ensures that each of the 50 states draws their congressional district maps to meet strict federal standards while also utilizing their own state-specific criteria. So we are going to look at these 4 things just so that we understand the ingredients that go into the process. The first one is federal constitutional law. We have 3 pieces specifically that are relevant to this process. Article 1, Section 4, the Elections Clause, which is what grants each state the primary authority to decide the time, place, and manner of holding congressional elections in their state. Article 1, Section 2, the population equality article and section has been interpreted by the Supreme Court to mean that congressional districts within a state must be drawn with populations as mathematically close to one person and one vote as practicable. And then 2 other pieces of federal constitutional law, the 14th and 15th Amendment, which prohibit racial gerrymandering, meaning race cannot be the predominant factor in drawing district lines. The next set of relevant considerations in doing redistricting are pieces of federal statutory law. So we're calling out 2 here on the slide. One is the Voting Rights Act of 1965, often abbreviated as the VRA. Section 2 of that piece of legislation, which has been renewed at least once, says that any voting practice or map that results in the denial or abridgment of the right to vote based on race, color, or language minority status is not permissible. This heavily restricts what's called vote dilution, which I'm going to talk about in a couple of slides, and may require the creation of majority-minority districts in that particular state where a distinct minority population is large and compact enough to elect a representative of their choice. The other specific relevant piece of federal law is the Uniform Congressional District Act. This was enacted in 1967 and mandates that representatives be elected from single member districts rather than at large statewide voting. So the entire state doesn't get to vote for your congressional representative, only the people in that district. The third bucket, and we only have one more after this, that apply in what you have to consider in doing redistricting is judicial precedents. So there are 4 specific cases called out here on the slide, but the one of them that is going to be most relevant to our discussion today is the third one, Rucho versus Common Cause. This was a 5-4 ruling that partisan gerrymandering claims present political questions that are beyond the reach of the federal courts. And this effectively prevents federal judges from striking down congressional districts for having been drawn to favor of political party, though plaintiffs can challenge them using state level laws. And this is very relevant to our current conversation. The last set of considerations of governance, forms of governments, are state laws unique to each state that have to do with congressional districts or districting in that state. Because federal law grants states that initial drawing power to draw the districts for their states, it is state constitutions, statutes, and redistricting commissions, if states use them, that fill the remaining gap in terms of process and instruction on how to do this. So depending on the state, there could be state level laws that might define how lines are drawn by mandating criteria such as the 4 that you see on the slide: contiguity, compactness, the preservation of political subdivisions, and communities of interest, grouping together areas with shared social, cultural, or economic interests. Not all states use these criteria, but these are commonly used in many states in whatever definition that particular state might have of how they have codified how districting will be done in their state. And we're going to see a reference to almost all of those criteria when we look at Florida's Fair Districts amendments when we get to that point. Okay, so gerrymandering. So before we zoom in on Florida, we're just going to still at the national level, at the theoretical level, we're going to look at how districting can be used to dilute minority votes to prevent minority voters from gaining or holding political power. The map can be drawn using the same number of people in the same districts in a way that results in minority voters having less of a chance of electing their candidate of choice. And minority vote dilution commonly occurs in 2 ways: the one you see on your screen and then a second one: packing and cracking. The one on your screen, packing, is the term used when minority voters are compressed in a small number of districts when they could effectively have been distributed differently to control more districts, more representative to their population. An example of packing is when map makers draw one district that is over 90% of a single minority group, blue on the screen, when they could draw at least 2 districts with a 50% single minority group. A second form of minority dilution is called cracking. And I think this one is very relevant to what we've seen happen here in Florida this year. In cracking, you spread minority voters thinly into many districts, splitting or fracturing their vote and their voice. An example of cracking can occur if 3 districts are created that have 40% of a single minority population in each. If the minority population, and that could be a racial minority or a political minority, if they're placed within one district where they are 70%, the minority community would have an opportunity to elect a candidate of their choice. So you can see you start with a nominal number on the left. You can divide it up the way that they've drawn it up in the center, where you have cracked that blue community or that blue segment, or you can draw it in a more proportional outcome, as you see in the third box, where you end up with 2 gray districts and 1 blue district, which is more proportional to the overall makeup of that district or that area. So now that we've kind of covered the bases of what congressional redistricting looks like and what are the documents or the governance that feed into redistricting being done, we're going to now start to zoom in on Florida. So Florida's history of redistricting starts, if you just want to cover the entire landscape. There was definitely a period of early malapportionment where rural conservative areas held a disproportionate power for nearly a century, until there were court interventions that changed that. And the one person, one vote rulings of the 1960s forced those districts to be changed. So that was a long-standing approach to how districting was done in Florida up until the 1960s. We have another period of time where change came after the 1982 Voting Rights Amendment Act amendments were made. And at that point in time, federal courts and the Department of Justice required Florida to draw districts that prevented the dilution of minority votes. And this led to the creation of Florida's first minority access and majority minority districts in the 1990s. The next sort of historical marker or milestone event with regard to Florida congressional districting came in 2010, when, frustrated by decades of partisan gerrymandering by both parties in Florida, Florida voters took it into their own hands through a citizen's petition and approved a constitutional amendment specifically banning lawmakers in Florida from drawing districts that are intended to favor or disfavor a political party or an incumbent, and demanding that their districts be compact and respect minority voting. So that was another big change. And then coming even closer to the current time, in 2016, we had a case of redistricting that was not on the 10-year census schedule when the Florida Supreme Court struck down the 2012 post-census map because it violated our new Fair Districts amendments. And Florida was ordered, and a revised map was approved that was used in 2016 through the 2022 elections. And then really coming up to the recent past in 2022, there was a new congressional plan for districting that was done in special session in April of 2022 that took into account that new 2020 census data and the addition of one more U.S. House seat. There were serious questions raised about whether the 2022 maps adhered to the Fair Districts Amendment. However, state courts and a federal court subsequently upheld this map in March of 2024. So that's kind of the landscape, the history of redistricting in a Florida context. Again, redistricting has only happened in response to a Supreme Court ruling or a court ruling that finds that the current map is illegal. Now, also very important to our discussion of what's happening this year is the Fair Districts Amendment. So when the governor held a news conference on July 23rd of last year and began to make his case for mid-cycle redistricting, many of us had some level of confidence or belief that this would not happen in Florida because, unlike some other states who were going down that path, Florida has a very specific and constitutional ban on gerrymandering, including partisan gerrymandering. The amendments that we passed in 2010 as a result of the Citizens Initiative are captured in Article 3, Section 20 of the Florida Constitution, and they lay out the standards that voters approved in that constitutional amendment. for establishing congressional district boundaries. And specifically, our Constitution states that no apportionment plan or individual district shall be drawn with the intent to favor or disfavor a political party or an incumbent. And that's because Floridians reject partisan gerrymandering. Floridians of all political affiliations voted against gerrymandering in 2010 at 63%. And even recent polling in the past few months revalidates that Floridians continue to oppose partisan gerrymandering just as strongly as they did 15 years ago. And polling tells us that 66% of people support the idea of Congress banning maps that favor one political party. And I think it's just important for us to, I've underlined the second tenet or specification of the Fair Districts Amendment because that's going to be important to the discussion in the legislature of why the new map was put together in the way that it was and why it is then asserted that the Fair District Amendments are no longer valid and were not used in the production of our current congressional district maps. It's also just worth reflecting, as based on what we've talked about so far, that what Florida citizens intended when they passed the Fair Districts Amendment was to prevent the longstanding practice by the ruling parties in the legislature, Democrats for many, many years, and then Republicans, of drawing lines that favor their party, something that we in the league refer to as politicians picking their voters rather than voters picking their politicians. So just a couple more things about what redistricting is supposed to look like when it happens in Florida, how it's supposed to be conducted. We've already talked about the fact that redistricting is most properly and statutorily done every 10 years following a new census that gives us new population numbers. We know that we adjust districts to ensure the same number of people in each district nationwide. It's about 761,000 residents that would make up a congressional district if they're all the same size. We also know that most redistricting, almost all redistricting that happens mid-cycle outside of the census cycle is specifically triggered by a legal challenge or a court ruling. We know that in Florida, as is true in most states, the redistricting process is the purview of the legislative branch. It is not the executive branch. It's not the judicial branch. It is supposed to be the legislature that is supposed to take action to conduct any redistricting. What we also know, and this was really brought out by representatives and senators present in Tallahassee at the end of April, is that when Florida does redistricting under normal circumstances, it is a process that takes many months. Groups of people, multiple people with expertise are brought together to draw a variety of maps that, based on the population numbers and the rules, would be candidates to be the district maps based on that new population. And what normally then happens with those maps that are put forward is that they are taken out across the state and in the communities and are presented for review and comment. There are town halls, there are committee meetings, there is a lot of discussion and input that takes place as new maps are put forward for redistricting. And we heard veteran lawmakers, especially in the minority party, describe how this process happened in 2022 to 2023. So now we're going to get into what has happened starting in 2025, but essentially what I will call 2026 mid-cycle redistricting. So, what I've laid out here in a timeline for you is just so you understand how we got to the end of April. So, as I mentioned before, July 23rd of last year, the governor first held a press conference proposing that Florida would do mid-cycle redistricting. In December, some of us got on a bus and went up to Tallahassee because the Florida House and Senate Select Committees on Congressional Redistricting convened. It was not a long process. They essentially came to order, did a short briefing about the history of district map drawing, and no public comment was allowed, and they adjourned not long afterwards. Nothing else happened until January when the governor issued a proclamation saying that there was going to be a special session for the sole and exclusive purpose of considering legislation related to drawing congressional districts for the state of Florida and to talk about any legal challenges and to appropriate funding. Then, according to the speaker at the special session at the end of April, it was about April 14th. He said it was about 10 days to 2 weeks before the special session started. There was a single staff member that works for the governor who began drawing a new map that would be put forward to redistrict Florida. On the 27th of April, the governor sent a transmittal letter to the legislature with the map and with his justification for doing this redistricting, but only after the maps had been sent to Fox News, color-coded as blue and red. The next day, House and Senate Select Committees met, and they both respectively approved the maps. The next day after that, the full House and Senate voted to approve the new district map, and then the governor subsequently signed that new map. So I went with a group of people from the local area, myself, up to Tallahassee and sat in the room that you see pictured up in the corner. I took that picture with my camera, and I am really pleased to be able to share with you. It's gratifying. I appreciate the opportunity to share with you what I observed and what I took away from being at that special session. So on the first day, well, I should first take note of the fact that many of the people in this audience did their very best to be part of a purposeful effort to engage senators and representatives, whether that was in person or through calls, letters, and postcards. And many people filled the committee rooms both in December 2025 and again at the end of April, most of them seeking to object to mid-cycle redistricting and calling for our Constitution to be upheld. After the governor postponed the start of the April special session in an attempt to line up the special session with the anticipated Supreme Court ruling on the Louisiana case, we found ourselves again in Tallahassee on the 28th of April. On day one of the special session, the House and Senate Select Committees respectively met. And what happened in that session is that the governor's map maker and his legal counsel gave a presentation, an explanation of the proposed map and their legal basis. And this took about 45 minutes, during which we learned several things. We learned that this map was made by exactly one person, and he was asked specifically about this and claimed that no other person was involved in the generation of and the architecting of the maps. He said it took him about 10 days to 2 weeks to do it. We learned that the maps that have been approved at the end of April are based on the exact same 2020 population census numbers as the previous map was. We learned, and was confirmed for us, that the legislature, the Florida legislature, took absolutely no part in the generation of the map or of the underlying philosophy or process for how the map was put together. As I mentioned, we learned because of their testimony that the maps came to the legislature after they were already sent to Fox News, color coded in red and blue, and had been shown on Fox News television screens before the legislators, senators, and representatives had seen them. We learned that the assertion that lies behind doing this redistricting is that the second element of the Fair Districts Act, in their opinion, is invalid. And further, that the rest of the Fair Districts amendments are unseverable from that second stipulation, that they are all or nothing. And so essentially, what the governor and his legal counsel have done is, in their mind, unilaterally gotten rid of the Fair Districts amendments. They also argue that the population shifts that have happened since 2020, when we had the last US Census data, are cause to produce new maps, and that also the anticipated US Supreme Court ruling, even though it is not on a Florida case and not on the Florida Fair District amendments, that it would become the basis for curtailing the use of racial considerations and therefore invalidating all of the Fair Districts amendment. So that whole process took about 45 minutes for the map maker and the legal counsel to present their information to the House committee and then the Senate committee. Then there was a period of about 45 minutes where the committee members were allowed to ask the two presenters questions. That only took about 45 minutes because of all of the people that you see depicted in the committee. Only 3 of them asked questions. And they just happened to be the 3 representatives from the minority party. Once they had asked their questions, and the chair continued to warn them that if they asked more questions, there would be no time for public comment, they wrapped up, and then the chair read all of the names of members of the public who were there and who had submitted their name and their indication that they were opposed to this map. There were 52 that were read, and all 52 of them waived in opposition. After that, we had just over 1 hour during which the public was allowed to speak for the first time to the committee. All of the in-person testimony in the House Select Subcommittee was in opposition to the map. And then on day 2, the second day of the special session, the House and Senate convened and they voted. They had another period of debate within, and the ability to ask questions within the whole of the House and the whole of the Senate. But similarly, there were very, very few comments. There were 0 comments in support of the maps. There were a limited number of questions from the minority party that were heard out. What I'm going to do now, because they're only 45 to 60-minute clips, is I'm going to play you a few of examples of the testimony so you get a more direct feel for what the House Select Subcommittee heard from the public on this date.
Good morning. My name is Amy Keith with Common Cause Florida. This map is a slap in the face to the people of Florida. And you don't have to approve it. You can say no. The people of Florida made partisan gerrymandering illegal when we passed the Fair Districts Amendment in 2010. The people of Florida across party affiliations in poll after poll after poll have made it clear that they continue to oppose partisan gerrymandering today, and they oppose this partisan mid-decade redistricting effort. The people of Florida deserve to have a full voice in a transparent redistricting process, but they have been kept out of this process that has been conducted behind closed doors. The people of Florida deserve not to have their districts changed at the last minute before a midterm election. They deserve an opportunity to know their districts, the people voting with them, and the people vying to represent them. The people of Florida deserve fair voting maps. They don't deserve to have their communities chopped up for the benefit of a political party. Partisan gerrymandering is illegal in the state of Florida, and the people of Florida do not want it. Please vote no.
Thank you. Jessica Lowe Minor, followed by Harrison Lundy, Voices of Florida Fund. You're recognized.
Good morning, afternoon. The League of Women Voters of Florida was heavily involved in the Fair Districts campaign to add clear redistricting standards to the state constitution in 2010. Those standards, which prohibit partisan gerrymandering, were passed by 63% of Florida voters. Since then, the League has continued to advocate on behalf of the state's redistricting standards, and we speak to citizens groups regularly about this issue. Over and over again, voters tell us that they are tired of partisan gamesmanship, and recent polls show that a strong majority of Floridians oppose mid-decade redistricting. Despite what other states may do, Florida has an explicit prohibition on partisan map making. This current redistricting effort does not, in the League's opinion, comply with the state's constitution, and we hope you will reject it. Thank you.
Thank you. We have Catherine Ashby, followed by Dr. Rich Templin. You're recognized.
Hello, I'm here to urge you to vote against HB 1. There is no new consensus or census data and no court order requiring new maps. Mid-decade redistricting is not prohibited, but redistricting to benefit a political party is. That is exactly what is happening here. The governor's rationale fails for 3 reasons. First, even if the Fair District Amendment was deemed unconstitutional, there is no legal requirement to redraw maps absent a court order. Second, the governor in this legislature has no authority to declare a constitutional provision void. Only the courts have that power, and no court has ruled the partisan provision unconstitutional. Third, Calaisis has not been decided. The governor's entire rationale currently rests on conjecture. In fact, the United States Supreme Court in Rucho v. Common Cause cited the Fair Districts Amendment as a model for how states can address partisan gerrymandering. And in the League of Women Voters v. Detzers, the Florida Supreme Court emphasized the importance of transparency in this process. This process has been anything but transparent, and we all have a right to have representatives who support us and are elected by us. Thank you.
Okay, so I think that gives you an idea of what the tone of the room was like and what the 50-some speakers presented to at least the House Select Subcommittee. So now I'm going to, I should also just wrap up by saying that went on for just over an hour was the total amount of time that was allowed for public input, and each speaker was given about 45 to 60 seconds to speak. So, but as I've already told you and we laid out in the timeline, subsequently, both the House and the Senate voted to pass these new maps, and the governor then signed them. So within about a day or two, legal challenges started for the new congressional district map. So what I've laid out for you here is the challenge, is some information about the ongoing challenge to the maps that were passed at the end of April. On the 4th of May, 3 suits were filed. They've now been combined into one. They were filed asking for a temporary injunction and were filed in Leon County Circuit Court. You can see the list of plaintiffs who filed. Their complaints have all now been put together into a package. The assertion of the plaintiffs is that the new congressional map violates the Fair Districts Amendment that we have in Florida and cracks the Democratic-leaning cities across the state to favor Republicans as a step of partisan gerrymandering. It asks that state officials be required to use the 2022 map for this year's midterms. And that map, as I had mentioned earlier, has been upheld by both federal and state courts, and there has been no court action or court finding that would lead us to change the 2022 map. On the 7th of May, the judge that the case was assigned to, Circuit Court Judge Marsh, recused himself as the state requested because Judge Marsh is very, very active in the campaign for one of the officials who was involved in this map making, and so he's too close to it. So on the 15th of May, the case, the opening hearing was heard still in Leon County, but by Circuit Court Judge Hawkins, who is a circuit court judge who was appointed by Governor DeSantis. He did not make a ruling on the day during the hearing and has indicated that he will produce his written decision once he has the transcripts from the hearing on the 15th, which was last Friday. And then, of course, coming up on us very quickly, 12 June is the date that is the final qualifying date for the people running for these congressional positions in the state of Florida. One thing that just strikes me and is sort of the major I think encapsulates a lot of the confusion and the frustration of what we heard during the special session is this quote from Senator Don Gates, what he said during the special session. And I imagine most of you are familiar with Senator Gates, but he is a quite conservative representative. He's also been in the Florida legislature for a long time. So he has seen how redistricting is done historically in our state. He is familiar with the laws. He was there when the Fair Districts amendments were put into our Constitution. And it is just striking to me that he would say what he said, and that is that I believe that the rest of the Fair Districts Amendment could and should and ought to stand. I don't think we should do gerrymandering on the basis of political partisanship. I believe that we should be required to follow all of the other demands of the Fair Districts Amendment. Okay, so the House passed it, the Senate passed it, the governor signed it. What does it mean for us here in Manatee and Sarasota counties and our surrounding counties? What is the local impact? And this is going to be the last thing I'm going to cover, and then we're going to go to questions and answers. The congressional redistricting in District 17, where Sarasota is one of the major pieces of the district, prior to this redistricting in April, their district encompassed all of Sarasota and Charlotte counties and part of northern Lee County. With the new map, the district lost the east inland portion, and if you can see the map where there is a red portion marked over the gray on the far right-hand side, I have, in a very amateur but mostly accurate way, flagged the portion of Sarasota County. It's essentially Route 75 east and north. Has been moved out of the congressional district that the rest of Sarasota County is in and moved into the congressional district with Manatee. And then to offset that population loss, there were portions of Fort Myers and Lee County that were added to to District 17. But overall, it's as what I've seen estimated is about a 15% change to the overall population makeup of that congressional district. You'll also see a note on the bottom that also I think the league raised a concern about to the legislature, and that is that there is a cost associated with doing this type of mid-cycle redistricting. The estimate is $13 million anytime an out-of-cycle redistricting is done. Now we're going to switch over to Manatee and Manatee's neighbors and partners in District 16. So the change was much, much more significant for our congressional district in Manatee County. What you'll so in the first thing you see is just a geographic map with Manatee County, which kind of looks like a right angle with a raggedy side. But just so that you can then try to transpose that onto the congressional district maps. So what happened in this redistricting is that the portion of southern Hillsborough County with the red lines dashed across it was in our congressional district. That's the area where Ruskin, Apollo Beach, those kinds of areas just north of our Manatee County line. All of those people got moved into a congressional district attached more to Tampa. That leaves Manatee County, but now it's combined with parts of Pinellas County. These are all of the dashed sections on the lower map in the far bottom corner. This is sort of southern St. Petersburg, the area across the Skyway Bridge. Those people came into our congressional districts, as did all of the people in DeSoto County, all of the people in Hardy County, the people in the shaded portion of Polk County, and then, of course, the people in the shaded portion of Sarasota County that were moved into our district. So we went from one county with a portion of Hillsborough to 3 whole counties with parts of 3 other counties. I have seen an estimate that this is a net 50% change in the people that are in this congressional district. And I will just point out that whether I support the particular candidate or not, I do feel for a candidate that I have heard recently talk about the fact that they were running for to be our congressperson in this district, and they spent the past year getting to know the people in the southern part of Hillsborough County. That now is completely lost effort because they are no longer in the congressional district, and that candidate has not spent 1 minute or had any real opportunity to get to know the new voters in this district from Southern Pinellas, Polk, DeSoto, Sarasota, or Hardy counties. So the candidates are adjusting, and then we have supervisors of elections in 6 counties who have to make changes to ballots and registration cards to reflect this massive change in who the voters are in District 16. So you can see it's a significant change. There were equally horrific stories from various parts of the state, including Orlando and the Miami area, where there have been drastic changes because of this redistricting, which had no foundation. There was no court case to trigger it, but that is what's happening. And with that, I think we have 10 minutes left. And so I'm going to stop sharing and I'm going to turn it over for questions.
Okay, Terri, just one question so far. I suspect more will be coming here, but it's a comment followed by the question. It seems the basis of districting rules practices assumes that a cluster or concentration of like citizens of a minority subgroup deserve their own representation. Is this based on the assumption that the members of that group deserves and wants someone like themselves to represent them?
So I think I apologize. I'm a little distracted because I'm trying to get back to the non-share view and it's taking me a moment. There we go. Okay, I think that is a fair assertion, right? But I just have to say, one of the things that I didn't play you the recording of me testifying at the committee because you're already having to listen to me for 50 minutes. But one of the things that just was on my mind as I spoke to them is, we have very clear, very purposeful amendments in the Fair Districts Amendment. And if you will so callously disregard those things that we, the voters, have put into our laws and our Constitution, what other things that we have legally voted in and support as voters would you so callously disregard? And so, as you said, I'm not sure that that is as much a question as a comment, but I think it's a very fair observation about what is supposed to be happening here and what is really happening here.
Okay, thank you. I asked folks, if you have questions, please put them in chat. This is the opportunity to do that.
I think Alice has her hand up, so we'll let her.
Well, let
Yeah.
Alice go. Sure.
Yeah, I started to type it and I went, this is too long. So there seems to be a concentration of attacking this because it's partisan gerrymandering. But there's a whole bunch of other things that it violates in the, for instance, you're supposed to be geographically connected. Well, I don't think the Sunshine Skyway Bridge counts as geographically connected. Do you know in these filings that have gone forward to get
in Leon
emergency relief, if they are going at it from anything but a partisan or standpoint? And I know they all had time to say something. Were they coordinating, or how did that all work?
Yeah, so I think that the major point that's being made about in the filings is about the validity of the fair districts maps, that they have not been repealed. No court has thrown out the fair districts amendments. And so the assertion by the governor that they are no longer applicable is invalid. That's the major point that's being made. But there are so many things that are improper about what's happened, the way that it's been done, the lack of opportunity for public comment, the lack of multiple maps that could be compared and contrasted for how well they do or don't adhere to the requirements for a districting map. The fact that the legislature had absolutely nothing to do with it, and it is their process to run, is invalid. I was struck, just really, I will just use the word horrified, that not a single member of the majority party said one word in favor of this new map. They didn't try to justify it. They didn't try to support it. They just voted for it and had took no time to articulate or to try to explain to the public that was assembled there why they were supporting this map and why this redistricting needed to happen. So I think it mostly hinges, Alice, on the fair districts amendments, but I know that there are so many things about this process and the way that it's been done, including, I know that the lawyers will be pointing to the fact, if somebody tries to say that it's not partisan, that it was sent to Fox News in red and blue before it was even given to the legislators. So I think a number of things will be brought up. There are numerous examples of where the geographic cohesion makes no sense. I mean, look at how our district has ended up. What is the commonality between someone who lives in southern St. Petersburg and Pinellas County and someone who lives out in the most rural part of DeSoto or Hardy County, right? And these are the kinds of things that when you do a normal redistricting where multiple maps are put forward and multiple maps are discussed in terms of pros and cons, that you would have the opportunity to flesh that out. And that is just not what has happened this year in this process.
Okay. Several more questions came in. This is great. So will the new redistricting go into effect immediately if the court rules for the new maps, or would they be paused based on any appeal that might be made?
So given any intervention from a court, an injunction or some other finding or act on the part of the court system, these are maps that are being implemented in this year for this election cycle, for the primaries and for the general election. Now, we have heard that supervisors have been told, keep your previous map on hand in case something happens, but something has to come out of the court system. There has to be an injunction or a stay in order for these maps to not be used this year.
Okay, thank you. And the question is probably on a lot of people's minds. We'd like to know what can be done to undo this.
Yeah, that's a great question. Well, I think not that it will directly it doesn't make the map go away in the immediate instance, but everyone, I feel, ought to be giving their representatives and senators an earful about the irresponsible way in which they have approached this redistricting in this special session. I think you need to make those opinions known. But barring that, it really is down to the courts, and I would hope that everyone would support the legal team. Court cases are not cheap, so if you want to throw a couple of bucks into the hands of the organizations that are filing this suit, they could probably use your support in trying to get something done about these maps. But we are really, I think, whether it's about the Fair Districts Amendment and this congressional map, or it's just about governance in our state, period, we need to be having a serious conversation with our representatives about upholding our Constitution and respecting the laws and the decisions of the voting populace, right? Whether it's on this topic specifically or any other, but this is just an egregious example of our legislators just having blatant disregard for things that we have specifically spoken on. And that was the other thing that was just so galling. This idea, and what I said when I got up to the microphone to speak, is even if you want to, without sufficient basis, assert that the second stipulation of the Fair Districts map is invalid, to say that they are inseparable, that they are non-severable, when you know that Florida voters told you very clearly that they do not want their districts politically gerrymandered, is just a slap in the face of all Florida voters. And it really does have to raise the question of what part of the laws that we pass, what parts of the Constitution that we vote amendments into, will they pay attention to and will they uphold?
Okay, are you hearing anything about what candidates are doing in response to this? I know there are cases where there are several now in one district that are incumbents.
Yeah, candidates are scrambling because, as I described, there are people who are running for congressional seats who had been, as they should, engaging the voting population of what they understood was their congressional district. They're now having to, in some cases, go introduce themselves to voters that they have never been engaged with previously. And they haven't directed their advertising. They haven't been doing town halls. And so it is a huge scramble. And in some cases, the person that they thought they would be running against is moved into another part of the district and is no longer running against them in their particular district. So it really is very confusing. And that's another thing that, as advocates of voters, we were trying to point out to the senators and representatives, is that this is, and you heard some of the video clips that I played, right? It's unfair to the voters. It's unfair for their district to be changed at the last minute. It's unfair for them to not have time to get to know the candidates that are vying to represent them. It's unfair and costly to the supervisors of elections who are trying to run an election properly in the midst of all this chaos. And so candidates are having to shift gears and deal with the chaos, but so are voters and so are supervisors of elections.
Another question. Do you think that the court process is working through? Is there anything else that would potentially stop or pause it from taking effect this year?
Not that I'm aware of. I will take that. I will take that as a question to try to get some additional information on, but not that I am aware of.
Okay, thank you. That's all the questions that have been submitted. I went through those. I suspect because you were so thorough in your presentation, many questions were answered right up front.
Well, and conveniently, we have come to the end of our hour time slot, so that works out just nicely. But it is a very complicated and important topic, and I encourage anyone who has a follow-on question. We are willing to go talk to additional groups of citizens here in the county if there are groups that would like to hear this kind of a presentation. And I encourage you to give your representatives and your senators an earful about the way that they have disregarded the will of Florida voters. So thank you for your time, and thank you for caring about what's happening in Florida with our rights as voters and our voting districts. Let's stop.